The LA County Board of Supervisors voted on January 25th, 2022 to extend the Los Angeles County Eviction Moratorium. You're probably wondering, what does this mean for Los Angeles landlords and Los Angeles tenants? Can a landlord evict a tenant to move in? What about non-payment of rent? Can a tenant be evicted for this? We're going to run through the exact timing and the 3 phases of the Los Angeles County Eviction Moratorium. Hey there, Christian Walsh, real estate agent with Wire Associates. We've been helping tenants and landlords and buyers and sellers since the beginning during these crazy days in California and beyond. The LA County Eviction Moratorium covers all unincorporated areas in LA and those incorporated areas that do not have an eviction moratorium in place. Now, bear in mind that LA City has its own eviction moratorium, and that one is also slated to end sometime in 2023, potentially at the end of 2023. That is a different moratorium. There are some similarities, but in this video, we're going to cover the Los Angeles County Eviction Moratorium. And we have links below to the things that we share in this video, including a copy of the motion that was signed to extend the moratorium. We encourage you to read through that. And remember, we can't give tax or legal advice, but for the most honest and up-to-date real estate advice, subscribe to this channel. A few very important points for this video. This is for both tenants and landlords. So this is a guide so that both will understand exactly how the eviction moratorium affects them. The LA County Eviction Moratorium has been extended for commercial properties, residential, and mobile homes. In this video, we will dive into residential, which has some overlap with mobile homes. We will not be covering the extension for commercial properties. I encourage you to read the motion to better understand protections in the event of a commercial property. The motion document addresses harassment and retaliatory actions as well, and this is from landlords towards tenants. And this isn't exclusive to the eviction moratorium. It's just plain wrong to harass and retaliate against tenants, landlords. And this includes, but is in no way limited to, turning off utilities, changing locks, calling immigration, making life difficult, or threatening tenants. These type of behaviors should not happen whether there's an eviction moratorium or not. But landlords do note that if you're caught in violation, there are very stiff fines of up to $5,000 per violation per day or more. And remember, tenants, if you cannot afford to pay rent, please make sure you apply for the California Rental Assistance Program by visiting housingiskey.com. Landlords, we encourage you to apply and cooperate as well. We've released a ton of content on housingiskey.com. Please take advantage of this resource while the funds are still available. We're going to discuss some of the eviction protections laid out in the Los Angeles County Eviction Moratorium, and it boils down to at fault versus no fault. And what do we mean by this, at fault versus no fault? It basically is the tenant's fault. So if it's something that the tenant has done, such as a nuisance or moved an additional occupant in, that would typically be considered an at-fault reason to terminate a tenancy. Non-payment of rent is the biggest at-fault reason to terminate a tenancy, typically. No fault would be it's nothing that's the fault of the tenant. And there's 4 specific ways a tenancy can be terminated for no fault reason. The Los Angeles Eviction Moratorium doesn't allow any of these except for owner move-in. And we're going to dive into exactly what owner move-in means. It's important to note that the Los Angeles County Eviction Moratorium is not going to allow a landlord to terminate a tenancy to do an extensive remodel, and they will not allow a landlord to take their property off the market either. This is a summary. We have a link below to this. This was issued by LA County the day after the extension of the moratorium was put into place. And we expected that they will release more content. Their website, which is very thorough, is in the process of being revised. But they put this out quickly, and we're going to use this to kind of jump off into the different sections and explain exactly what's going on. What it does at the very beginning is break things down into phase 1 and phase 2. It doesn't mention phase 3. Phase 1 is February 1st through May 31st. And then phase 2 is June 1st through the end of the year, so through December 31st, 2022. This is what's to be expected through 2022. And then phase 3 will take up 2023, the entire year. One thing that will stay common in phase 1 and phase 2 is the rent freeze. If your property is under the Rent Stabilization Ordinance, an RSO property, the rent freeze will stay in place, and that's all through 2022. At some point in time, landlords will be able to raise the rent in 2023. Let's dive into phase 1. And again, we're not going to cover any of the commercial aspects of the eviction moratorium that is addressed in here, but we're not going to go over that in this particular video. Tenants in LA County are protected from eviction for no fault eviction reasons. It says except for qualified owner move-in, and we're going to dive into that towards the end of the video. It is still very difficult for a landlord to qualify for owner move-in. A tenant cannot be evicted for nuisance, unauthorized occupants or pets, or denying entry to a landlord. Now, this was unique to LA City and LA County for the eviction moratorium. The statewide eviction moratorium did not have the provision related to denial of entry by the landlord. Throughout the rest of the state of California, a landlord was still able to go into the unit, check on smoke detectors, water heater, carbon monoxide detectors, or show to prospective buyers or get an appraisal, things like that. Uniquely in LA, if a tenant said, no, I'm not going to let you in, they couldn't be evicted. Everywhere else in California, if a tenant said no, they could. So that's interesting. So that is going to stay. It will change in phase 2, but it stays in phase 1. The biggest reason for the eviction moratorium, I'm talking about at the state level and the local level in LA County and City, was to protect tenants from being evicted for non-payment of rent. Obviously, COVID affected a lot of folks financially, so that's why these eviction moratoria were put in place. The statewide eviction moratorium has been over since the end of September 30th. This one is still in place and has just been extended. And you can see here that they mention the effective date of April 1st, 2022. Why is it that these protections go back into place? Well, that is tied to the statewide eviction moratorium. And what it says right now is that if a landlord is going to attempt to evict a tenant for non-payment of rent, whether it's COVID related or not, the landlord must first apply for state rental assistance. And then if the tenant doesn't cooperate or funds run out, the landlord can move forward with the eviction. What this is doing is this is replacing that. When that expires March 31st, this will then take over, and it will mean that landlords will not be able to move forward with an unlawful detainer due to non-payment of rent. Theoretically, what this says is that the tenant is only protected if the non-payment of rent is due to COVID-19. So they've been impacted by COVID-19. It specifies that there was an increase in expenses, a loss of income, etc. The challenge for landlords is that it's a self-certification process by the tenant. They can basically say that COVID is affecting their ability to pay rent, and they do not have to provide any proof to the landlord that that is the case. Now let's dive into phase 2. So this is from June 1st through December 31st of 2022. One of the big changes you'll see in the at fault is that is gone in the case of denying landlord entry. What this means is with proper legal notice as of June 1st, 2022, a landlord can enter the unit. And that would be, again, to check smoke detectors, water heater strapping, to check this carbon monoxide detectors, to do any prearranged repairs that need to be done, and to show to prospective purchasers, etc. A landlord will be able to give proper legal notice and enter the rental unit. If the tenant does not let the landlord in after proper legal notice, that tenant will be at risk of eviction. Now, the other two changes in here that happen are related to owner move-in evictions. And we're going to run through owner move-in evictions now to explain this. These are relatively minor changes, and we'll show you exactly what they are. A big change in phase 2 comes related to non-payment of rent. So after June 1st, 2022, if a tenant is at area median income of 80% or less, they are still protected in the case that they can't pay rent due to COVID-19. That's an important point. Anyone over, so 81% or more of area median income, after June 1st, 2022, they're no longer protected for non-payment of rent due to COVID-19. They must pay their rent. Who determines whether they're at 80 or less or 81 or higher? It's up to the tenant. It's self-certification by the tenant to determine where their area median income is. They are not required to show any proof to the landlord of exactly where their income is. When can the landlord terminate a tenancy so they can move into their own property? Well, there are very, very limited instances. It can happen right now, but what it requires right now is that the owner of the property must have purchased it on or before June 30th, 2021. So if someone has recently purchased a property, they are not able to move into their rental property and claim it as a primary residence. That will change. So there will be two changes in phase 2. And the two changes in phase 2 are that requirement that the property must have been required after June 30th of 2021 will be gone. So after June 1st of 2022, don't get confused, lots of June dates. After June 1st of 2022, a landlord is going to be able to potentially get a tenant out so they can move into their own property no matter when they acquired it. It doesn't have to be before June 30th, 2021. So that will cover everyone who's acquired a property since July 1st, 2021 through May 31st, 2022. The other thing that changes in phase 2, and we're jumping ahead a little bit, is this requirement here. The tenants of the unit must be current on rent payments and not have been impacted by COVID-19. So right now, as we're going into phase 1 and I'm recording this, the only way a landlord could potentially get a tenant out so they can move into their property is if they meet these requirements and the tenant is paying on time and hasn't been affected by COVID-19. This requirement here will also disappear in phase 2. So after June 1st of 2022, it doesn't matter if the tenant hasn't been able to pay rent and hasn't been able to pay rent due to COVID-19, the landlord will potentially be able to terminate the tenancy to move in. Let's run through the rest of the list that will be in place in phase 1 and phase 2. It must be a house, a condo, a mobile home, a duplex, or a triplex. A fourplex or bigger will not be applicable. The owner will not be able to move into a unit. That unit, if the owner does move in or the owner's family, must be a primary residence for a minimum of 36 months. Another important one, the landlord or qualifying family member must be similarly situated to the tenant. And we're going to explain that. We're actually going to go into the language so you can see what that means, because that is the big caveat on this one. They also must give a 60-day notice, and if it is an RSO property, they'll have to pay the relocation assistance, which you can reach out to the RSO office for, and it is several months' rent and can be higher than that depending on the exact situation for the tenant that's living there. Now we're going to dive into the actual language in the motion so that we can get more of an idea of what is required in the event that the landlord wants to move in. It's all laid out here. I have a link below. I encourage you to read it. Remember, a family member is a straight line family member. So that would be a parent, grandparent, child, grandchild, or a spouse or domestic partner. So it's a straight line. It can't be an uncle or an aunt or nephew or niece. So in the event that the landlord owns 100% of the property, they can occupy up to 2 units. And that could be, if they own 2 houses as rental properties, they could take those 2 houses over. If they have 3 houses, they couldn't take all 3 over. They could only take 2 of the 3. It's important to dive into this because you can quickly see how the owner move-in falls apart. And there isn't really an easy way to do it. And here's where it gets even more specific. This was kind of glossed over in the summary. It's a similarly situated sentence. Boy, there's some alliteration. And what that means is defined here. In order for the landlord or the landlord's family to terminate a tenancy to move into a unit, there's going to have to be a tenant who's similarly situated. So if the tenant is 62 years of age or older, then the landlord or the landlord's family who's moving in has to be 62 years of age or older. If they happen to have a disability of any sort, if the tenant is disabled, then the landlord or the landlord's family must be disabled in order to move in. A terminal illness, same thing. They must have a terminal illness to reside in the unit. And if the tenant is low income, only a landlord or family member who is low income can move into the unit. So this is an important qualification that tenants and landlords need to understand if a landlord is going to attempt to move in to a rental unit in phase 1 or phase 2. And we said we mentioned phase 3, so that is all of 2023. And remember, the rent freeze will eventually thaw then, and theoretically rents will go up. The Rent Stabilization Ordinance Office, the RSO office, will let you know how much you can raise rents in 2023 and when you can as a landlord. And the eviction protections will remain in place for those at 80% of AMI or less. So that is the plan as of right now, to leave that in place. And what it says here is basically that it may change and they've got more time. They may add additional layers on for phase 3. The goal is to phase out of these eviction protections at some point in time. And based on this plan, phase 1, 2, and 3 are a 2-year phase out that potentially could take longer. Okay, let's try to get through a quick summary if you're still there with me. Summarizing phase 1, so February 1st through May 31st. Tenants are protected from eviction for no fault reasons except for owner move-in. And we ran through what that owner move-in meant. And don't forget in phase 1 that if the property was acquired after June 30th, 2021, that the landlord can't move in. And if the tenant isn't paying rent and not paying rent due to COVID-19, then the landlord can't move in. That comes in phase 2. Nuisance, unauthorized pets, or occupants cannot be evicted. If the tenant denies entry to the landlord in phase 1, tenant can't be evicted. And starting on April 1st, 2022, are the rental protections for non-payment of rent due to COVID-19. Okay, in phase 2, June 1st through December 31st, 2022, the quick summary is, remember, no fault eviction reasons, can't evict other than owner move-in. What's different in phase 2 is if the property was acquired after June 30th, 2021, the landlords can now do an owner move-in. And if the tenant has been affected by COVID and is not paying rent, doesn't matter, landlord can do an owner move-in. Also, nuisance and unauthorized pets and occupants, those remain. But what changes is the tenant must let the landlord in with proper legal notice. If they don't, then they can be evicted. The other big change in phase 2 after June 1st of 2022, if a tenant doesn't pay rent due to COVID, they have to be at 80% of area median income or less in order to receive the protection from eviction. And it is self-certification. So the tenant has to say that their income is 80% or less. There's your quick summary of phase 1 and phase 2 of the LA County Eviction Moratorium. I'm sure you still have questions. Please be sure to leave those below and we'll do our best to get you an answer or direct you in the correct direction to get the proper answer. Again, we can't give tax or legal advice, so please make sure you reach out to the appropriate professional. We can give you some direction on attorneys to turn to, whether you're a tenant or landlord. Please join over 2,000 subscribers for our free weekly email newsletter where we cover topics like this, plus a whole lot more for tenants and landlords and buyers and sellers. Make sure you tune into this next video for more information for tenants and landlords during these crazy days. Thanks for tuning in. This has been Christian Walsh, real estate agent with Wire Associates, and we appreciate you.